floor in this honorable court.
Thank you. You may be seated. All right, we have two cases on our agenda this afternoon. The first case, case number 23-2284, Alana Megarejo versus Robert Seibert is the first case. Appellant's counsel, when you're ready.
Thank you, Your Honors, and may it please the court. My name is Andrew Greenlee, and I represent the appellant, Ms. Melgarejo. I'd like to reserve 5 minutes for rebuttal.
Noted, thank you.
Thank you, Your Honors. I'd like to first start with the first issue that was raised in our briefing regarding the introduction of remote in time MDMA use by the plaintiff. And we know from Browning and we know from Shaw that the default rule is that personal drug use is inherently prejudicial and it shouldn't be admitted absent some sort of special circumstances. In this case, it was admitted under the theory that it was going to be an alternative cause for the brain injuries that she suffered. But actually, when it came time to try the case, there was no testimony that affirmatively linked the injuries that she suffered with the MDMA use. In fact, the defense denied that she suffered any injuries whatsoever, and they prevailed.
At that point, should there have been some sort of an objection or move to strike the testimony of the expert in order to preserve this issue, or where are we? Because it seemed like, you know, pre-trial that the judge made the ruling that, okay, because of how the expert's going to tie this together, that's the basis for the ruling. But then when the expert doesn't tie it together,
right,
wouldn't there be an obligation to object or?
Well, Your Honor, it's our position that the preservation begins and it ends with section 90.104. And under that rule, once you've obtained a definitive pretrial ruling, you're good to go. You don't have to, lodge any type of contemporaneous objection to the introduction of the testimony. In fact, the reason for the rule, we believe, is that it would draw more attention to it if you had to continually stand up and object every time it's introduced into evidence.
But I understand your argument to be it's not so definitive once the other party doesn't put on what they said they were going to put on with the expert.
Actually, Your Honor, this is a very important point. I'm glad you brought it up. The MDMA use had already been introduced before Dr. Herkloff even testified. It came in through plaintiff's own expert first. So the cat was already out of the bag. The jury had already been exposed to this incredibly prejudicial testimony through plaintiff's own expert. So I understand the argument on the other side is, well, you didn't move for mistrial when Dr. Herkloff had testified, but his testimony was after MDMA use had already been introduced to the jury. So in addition to that, the grounds for the preservation were actually made in the argument on the motion in limine. First, counsel said, I can't see the relevance. So that's the same argument that we're raising on appeal, relevance. And that's at page 152 of the transcript. Second, in the pretrial motion, he said it should be excluded under 90.403. That's the same argument that we're making here on appeal. And third, he even kind of envisioned that it was pretextual, that the introduction of the MDMA, he said the real reason for introducing it is just to prejudice the plaintiff. Now that together, those are the same arguments that we're raising on appeal. And because we presented those to the trial court, we obtained a pretrial ruling, and we didn't have to object or move for mistrial. Of course, counsel.
Wasn't the pretrial ruling that I'm denying your motion without prejudice? I want to see how this factors into the medical experts.
That was on the motion in limine, but then right before a trial, I believe it was during jury selection, they obtained a definitive ruling. The judge said, I'm going to overrule your objections. We have an expert here. And so that was that. That's the definitive pretrial ruling. We obtained that, and I think it's around page, like 153 of the transcript. And they credited the...
Wasn't the objection, the objection though was, it's a 403 objection in advance.
Well, he also said during the argument, he said, I can't see the relevance.
Well, but that is a 403. How do you deal with relevance directly pre-trial? I mean, I can understand there are certain specific objections you can
Right.
make and have them dealt with, but how do you deal with relevance generally before the trial even happens?
Well, I think
It
it's,
seemed to me there was a 403 objection. that
well,
was
there
made.
certainly was a 403 objection. I'm just saying our objection was really twofold. He did say in the argument, I can't see the relevance, and that was because it was more than 20 years in the past. I mean, think about that for a second. How could it possibly be that it impacted her, her brain functioning when it was that remote in time? Also,
Well,
the,
that's sort of a that's why the experts there was presumably to tie those things together, that,
Right.
yes, this usage 20 years ago, or however long it was, ties to what we're seeing
right,
now.
right, and he never did. No expert testified to that.
Well, what do we do with your Second Amendment motion for new trial actually seems to say that he did tie it together. Defendant's experts, Dr. Herkov, went to great lengths to convey to the jury that it was her remote in time ecstasy use that played a significant role in her current cognitive condition. So it seems like you're arguing something a little different here that you argued on your motion for new trial, which sort of conceded that he actually did tie it together.
Well, Your Honor, that motion in new trial was prepared before the actual, I didn't prepare it. That was prepared before the transcript was actually ready, and was prepared. And if you actually look at the transcript, there is no testimony. There's no causal link. My friend on the other side talks about testimony where he said something along the lines of, well, it could have impacted another person, a person generally could have memory issues because of this.
So I guess what I'm hearing here is that the judge below never had this argument that there was that the expert insufficiently tied,
Well,
because you even told the judge that he did tie it together and that was the problem.
just to be clear, Your Honor, our argument is threefold. All of these arguments were made. Number one, it's irrelevant. Number two, that it's unduly prejudicial under 90.403. And there's no dispute that that argument was made and it was ruled on and overruled. And the third was that it was pretextual. See, the counsel said, and this is prior to trial, kind of anticipating that there would be no connection, the real reason for introducing it is to place prejudice upon the plaintiff. So we do disagree that it was insufficiently preserved. We think that it was preserved. We obtained a definitive ruling prior to trial. And again, the bigger point, though, and this should be decisive on this, it came in through our own expert first. So there can be no real dispute that it was objected to. We obtained a definitive ruling at the very least on the 90.403 issue, and then they questioned our expert witness, about the MDMA use. So it was.
How did that expert know about the MDMA?
It was. I think it was listed in one of plaintiff's one of her medical records.
Right.
I think that. So there was some notation in the medical record that 23 years I think it was prior to trial, she had used recreationally MDMA.
So those are records that the plaintiff's expert had relied on to reach his opinion.
That's right. And he ultimately
So isn't that
concluded.
fair game then for cross-examination at the point to ask about evidence that or documents and information that the expert relied
Well,
on?
we don't think it's fair game. We think it's subject to exclusion under 90.403. It might be one thing. Again, if you think about what the probative value of it was at trial, none. They said that she didn't suffer any injuries whatsoever. So the probative value drops out at that
But
point.
that's at the back end. That's what one of the first questions was, well,
Right.
at that point, the circumstances changed, so now it's a different argument.
Well, it's not a
As to why
different.
it's, 403. I mean, 403, in advance, you're balancing, anticipated evidence.
Mm-hmm.
And then when you get into trial, if the balancing is put off balance because the probity has now been diminished because the defense case, the evidence didn't rely on that the same way, doesn't it change the circumstances and behoove you to then raise a new objection?
Look, counsel, I suppose, could have. He could have over-preserved the issue, but look, 90.403 was squarely before the trial court. He said, it's over 20 years in the past that this recreational drug use took place. I think that it falls squarely within the normal rule, the default rule, that it should have been inadmissible, and the fact that they made a tactical and strategic choice to unilaterally diminish the probative value of their own evidence, I mean, that they shouldn't be allowed to get the benefit from that, from misleading the trial court. Imagine what kind of sharp trial litigation tactics might arise if you approved of that. I mean, we should be the ones, having raised the issue, we should certainly be allowed to argue on appeal, as we are here, that the probative value of it was slight, diminishing, almost none. And then if you look at the prejudicial effect, it's incredibly prejudicial. We had 3 different experts offer testimony about it. Keyword search, I love the keyword search. 41 times the topic came up between MDMA and ecstasy, 41 times. Then we have a note from the jurors effectively asking questions, equating it to crystal meth, which is a highly addictive substance with all sorts of stereotypes and connotations in popular culture about meth heads. I mean, you can only imagine what the jury might have thought. Oh, well, she's just going to take this money. We can't award her a lot of money. She's just going to take this money, and this meth head is just going to give it to a drug dealer. It's incredibly prejudicial. I mean, we think it's outcome determinative. And then finally, it was relied upon in closing arguments. The defense even said, we're not paying enough attention to this MDMA use. There's no way on these facts that it's either harmless, that it's not preserved. I mean, it's squarely preserved. And there's no way that it's not reversible error. We have, again, Shaw. We have Browning. All these cases, Shaw is we think it's binding on this court. It's from this court. Browning is even stronger for us. In Browning, the expert testimony was that drug and alcohol use by an expectant mother could potentially cause these same injuries, but nobody actually affirmatively said that they did cause the injuries. That's the same testimony we have here. So it was irrelevant. It was also subject to exclusion under 90.403.
Can I ask you a question about your issue 3, the jury
Sure.
selection? So obviously the juror that your client objected to did not serve on the jury, right? It was
Yes, we struck
as a
him peremptory.
And there was no reason given, or nothing specifically stated by plaintiff's counsel as to why that, was it juror 113, I think? Why that juror may have had a hint of bias or any sort of concern like that.
Right.
What is the error? So the error, I'm assuming the error that you're asserting is not the failure to deny a 4th peremptory. The error is the failure to strike that juror for cause.
That's exactly right. The failure to strike a juror for cause.
And then your claim is basically that the cure, which happened here, which is the use of a peremptory, because the error didn't manifest itself directly, because what you would contend is a biased juror didn't actually serve. The
Right.
cure, I'm assuming you're arguing, was insufficient under the circumstances to solve the problem or to give you a fair trial. Is that
Well,
the
that's
argument?
right. We were effectively deprived of a peremptory challenge. I don't want to spend too much time on issue number 3. It's number 3 for a reason. That's not to say that we abandon that argument, but we think that the stronger issue by far is the first issue presented. And then the second issue presented, Your Honors, we have a damage award of $10,000 when her initial trip to the hospital standing alone was more than that. And then it was essentially stipulated to the defense.
But see, isn't that related then to your third issue? I mean, don't run away from your third issue so quickly. So you used a peremptory. Now, the other side says that following Sealer, the Supreme Court's, and Special, that in some way that there wasn't any, it was harmless, basically, because there was no indication that this person was biased, and in fact, they seemed to be maybe going your way. And you don't, in your reply, you don't address that. You just go back to the original juror that was stricken. So how did the use of that peremptory deprive your client of a fair trial?
Well, for one thing, you're allowed an allotted amount of peremptories. Had we had another peremptory, we would have stricken another juror. The juror who was stricken was, I believe, a machinist who raced four-wheelers in his free time. We're trying to try a plaintiff's case. We want jurors who are maybe going to feel it more from the plaintiff's perspective.
But didn't 113 feel, the 113 actually, I think was in an accident as well, or something like that. So wouldn't that,
Again, without revealing, the internal discussions, I didn't try the case, but again, without revealing any of the internal discussions, we do think.
But does the side that is arguing for that it was error or harmful error to have had to use a peremptory, does the appellant bear any burden to show, like, at trial, like, hey, I want to use this peremptory, it's interfering with, so the peremptories are there to ensure that you have an impartial jury.
Right.
It's ancillary to that or an adjunct to that mission. Is there any burden on the party objecting to explain why there is a concern about that juror?
We don't believe that there is. We think that all you need to show is that the initial cause challenge was wrong and that you request it, and then it becomes an issue of preservation. And then if we're right on that issue, then the burden is on the defense then to come and say, oh, well, it was.
And how do they meet that burden?
Well, I don't think they can meet that burden.
Why
we have a
didn't they meet
grossly
the burden
inadequate, pardon me?
Why didn't they meet the burden here in their
Well,
brief?
we have a grossly inadequate award of $10,000 that had to have been the product of either passion or prejudice against the plaintiff. And so we think that
Isn't that bootstrap, so you bootstrap what would be a sufficiency of the evidence or the manifest weight of the evidence into a juror challenge?
Well, we think the arguments do converge and dovetail nicely, in fact, because we do have, on the one hand, how do you explain the jury verdict? One way of explaining it is the jury was biased. We didn't get to pick a fair and impartial jury. Another way of explaining it is that there was MDMA use that was a feature of the trial. And again, the burden really is on them of showing that we did receive a fair trial. And all we're asking the court to do is follow its decision in Diaz versus Spick, where they said where there's stipulated amount of damages, it's not binding.
But the damage weren't stipulated, right? They just said that this would be a reasonable amount.
It was
They
a
didn't
reason.
stipulated to it. I think the ER expenses were 10.5, the jury verdict was 10. If the verdict here was 10.5, would it not be grossly inadequate, or what do we do with that?
It would still be grossly inadequate. Again, by their calculation, around $30,000 would have covered it. So we're already talking about 3 times the amount of the jury award. And then whether you want to call it a stipulation or whether you want to call it the reasonable estimation of counsel as far as damages are concerned, their attorney also said for future medical expenses, we'll peg that around $100,000. So now we're at, it might not be stipulated, but it's their conservative estimate is $130,000. $10,000, we're talking about that's 13 times more. So it's grossly inadequate. There were thousands of pages of medical records. She suffered a traumatic brain injury. Of course, there was testimony.
That's disputed, right? And that's
That was
what the jury is weighing, whether
Right.
there's really an injury here, or whether they're arguing there isn't no injury there. And there's some expert testimony along that line. So the jury has these couple of things to weigh.
They have those things to weigh, but what gets in the way is this MDMA issue and the fact that we had to try the case against a jury that, in our view, wasn't fair and impartial. And, Your Honors, I've eaten into my rebuttal time. I'd like to sit. Thank you.
Thank you, counsel.
May it please the court, my name is Carrie Leininger, and I represent the appellee Robert Siebert. The objective evidence in this case painted a clear picture of a plaintiff who had been involved in a serious accident but was not injured. The plaintiff was assessed at the accident scene and was given a Glasgow Coma scale score of 15 out of 15. She was taken to the emergency room at Shands, and Shands, wanting to fully investigate a possible brain injury, ran all sorts of tests, did a CT scan, it came out normal. They once again assessed under the Glasgow Como scale, and again came up with a 15 out of 15. They discharged her from the ER that night with no restrictions, no diagnosis of a brain injury.
So what do we do
And
with
without-
this? I mean, I'm going to call it a concession during closing arguments where, you know, during closing, your team says 32,000 is reasonable for past medical expenses, 100,000 for future medical, and then we've got a $10,000 damages request. I know in the brief, there was an argument that was made that a jury can sua sponte, reduce or discount medical bills if they feel like they're unreasonable. Is that your argument?
Exactly my argument, Your Honor. A jury is always free to accept or reject the argument and testimony of the witnesses as long as there's a reasonable basis to do so. And in this case, there was an absolute reasonable basis to say after the plaintiff was treated and released from the emergency room, she didn't need anything else. And indeed, the plaintiff waited 9 days before going on to getting any other medical treatment, and that medical treatment was from a chiropractor. And so there was objective, clear evidence that the plaintiff did not suffer an injury. There was testimony from a radiologist who went through a list of about 10 films, and he said normal, 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 no trauma-related injuries.
So it's your argument not that a jury has the power to reduce medical bills almost under a technical basis. They can disregard a bill as treatment that wasn't necessary. There's a distinction there, so clarify that for me.
First of all, there was no stipulation, I think as one of the judges pointed out, there was no stipulation that all of these medical bills were related. The trial transcript and the position of the defense throughout was absolutely consistent. She did not suffer an injury in this case. The medical bill summary was put in to say, listen, if you do think she suffered an injury and you're going to start awarding medical bills, this is our argument or our position as to what we think is reasonable.
Would 0 have been reasonable?
I'm sorry?
Would 0 have been reasonable?
Your Honor, there's scant case law.
You just sort of said that once she was discharged, there was no further problem.
Right.
But that sort of...
Your Honor, there's scant case law on that issue, but there's been some DCA opinions that suggest that, going to the emergency room is compensable. And the jury did award that. The jury was free to say, we
Well,
think...
they came up short even there, right? There's a difference.
That's correct, but the jury's free to reduce the medical bills. The jury is absolutely free to say what they think is reasonable as long as there's a reasonable basis for it. And so jurors know that what is billed amounts and what is actually paid amounts are vastly different. Anybody who's received an EOB for medical care knows that there's a difference. And so the jury was certainly free to reduce that. It's pretty close. It's $10,000. I believe, I don't know if it was in front of the jury or not, but even the plaintiff's attorney said it was $10,000. And so $10,000 is consistent with her visit to the emergency room. But she gets discharged from the emergency room with objective findings that she was not injured. I think she was complaining of hip pain and leg pain, and that was it. She was discharged from the
the jury also had to disregard your own expert's testimony that she came away with PTSD. Is that right?
Yeah, there was testimony from one of the doctors who said based on her subjective complaints, she might have PTSD. But as we all know, diagnosis based on subjective complaints, if the jury ends up determining that the plaintiff is not credible, then the jury is then free to disregard that expert's conclusion that was based on subjective complaints. And the defendant's primary focus throughout this trial was impeaching the plaintiff's witnesses. And the defense impeached virtually every one of these witnesses. Either their testimony was not consistent with prior deposition testimony, or they hadn't reviewed records that they should have. And then the plaintiff herself was impeached with the surveillance video that contradicted her claims that she couldn't drive, she had difficulty lifting things. It showed her driving a car, it showed her cleaning out her car, it showed her lifting furniture. And so the jury saw a surveillance video that painted a very different picture of what the plaintiff had tried to convince this jury of. The plaintiff's voc rehab doctor was impeached on the claims of wage loss. The voc rehab expert said she's going to be this great massage therapist, she's going to earn in the 90th percentile, and hadn't even reviewed the tax returns to show that the plaintiff was earning around $15,000 to $30,000 a year and was nowhere near the 90th percentile. She was working 25 hours a week before this accident, and her primary job was going to music festivals to provide massage therapy. And so there was just a real lack of credibility in all of the plaintiff's witnesses. And the defense put on a CME doctor who was very credible. He's a neurosurgeon. He had been a neurosurgeon during the Gulf War in a frontline hospital and had extensive experience with TBI. Only 10% of his income is derived from medical legal work, and only a third of that is from the defense. And so this doctor gets up there and says, I examined her, I reviewed her medical records, she was not injured in this accident. And so the jury was absolutely free to believe that this plaintiff had a serious accident but had no injuries from this accident.
And if we have a concern that she went away with a $10,000 500 emergency room bill, but only got $10,000 worth of damages, basically she was out $500 for this accident, just for the
Yeah.
basic emergency room care. But you would say to me, well, Judge, that's not grossly inadequate, so that's not.
It's not grossly inadequate. The jury is free to decide what reasonable medical expenses are, and as long as they have a reasonable basis to do so. And they were free to say, you know what, we think this is a little too high for the emergency room bill, and so it was just a little short of it. But they awarded her $10,000 for that initial, presumably, I mean, there wasn't a special interrogatory on the verdict form, so we don't know exactly which bills they were paying, but presumably they were paying for the emergency room bill, and the jury was absolutely free to use their own common sense. They're told to do that. The jury instructions tell them to do that, and that's what they did in this case, following all the objective MRI films, CT scans, all the objective medical data that was in this case.
Can I ask you a question about the jury selection issue?
Sure.
First of all, would it be the same standard for a civil veneer person as it would be for a criminal veneer person in determining whether the person should be stricken for cause? So on the criminal side, we have to be certain beyond a doubt that that person is going to be impartial, or we shouldn't have a doubt that that person might be biased.
Yeah.
Is it the same standard for a civil juror?
Your Honor, I haven't found any case law that distinguishes between the standard for reasonable doubt.
Can you think of any reason why a civil jury should be treated differently?
You know, Your Honor, especially in some of the cases that were cited there, murder cases, somebody's going to go to
It's a
jail.
constitutional right to.
Yeah.
Presumably, do you agree that, because everyone has a constitutional right to a jury,
Right.
civil or criminal.
Right.
That includes the right to have that jury be impartial. Would you agree with that?
Right.
So with that, is it enough for the question to be asked in rehabilitation after a veneer person has given an answer suggestive that they might not be impartial? Is it enough just to say, hey, can you just follow the instructions and be impartial? Is that enough?
No, that alone is not determinative. The case law says that. But the Florida Supreme Court in Morantz versus State goes through a pretty lengthy analysis of this issue. And they divide jurors into sort of two categories: jurors who may have a bias, and that's jurors who have a bias based on a personal experience, a personal life experience. And those jurors who may have expressed a bias based on a lack of understanding or unfamiliarity with the law. And so in the Morantz case, it was a criminal case charging the defendant with burglary and murder. And the juror at issue in that case had expressed doubt that she could be fair because she had been the victim of burglary. And she had also had a close family member who had been the victim of fraud, which she kind of, joined the two. And then she said, the burglary was when I was 8 years old and somebody came into our house during Christmas and stole things from us. And I still hold a grudge to this day. And through lengthy questioning, if you read the Morantz opinion, there's about 3 or 4 pages of the voir dire. And over several days, that juror finally says, I think I can be fair. And so the Florida Supreme Court said, listen, in that circumstance, she had said she held a grudge. It had affected her. And by the way, that case was going to be tried during Christmas time. So there was a real personal experience and a real reason why she was going to have a bias in this case. And so, yeah, afterwards saying, I can be fair, the Florida Supreme Court understandably said, no, that's you just can't say I'm going to be fair after 3 days of questioning, especially based on a personal life experience. But in this case, Juror Beeler says, hey, I wouldn't file a lawsuit, or I don't think I would file a lawsuit. But he repeatedly says, when asked, well, do you think it's okay for somebody else to file a lawsuit? He says, I need more details. I need more details. I need more facts. And then he finishes up by saying, the plaintiff will have to prove more than the defendant, ultimately making a correct statement of what the law is. The plaintiff is going to have to prove more. Well, that's the law. The plaintiff does have to prove more than the defendant. And so that juror, to the extent there might be some concern about his questions, they were just based on his personal opinions that seemed to reflect maybe a misunderstanding or unfamiliarity with the law that you can bring a lawsuit. And so in those situations, yes, a question at the end that says, can you be fair, can you follow the law, can then serve as the basis for the judge to deny the cause challenge.
This juror is expressing sort of doubt as to whether the plaintiff should have sued in the first place. He says, like, one of the statements is anxiety, I've got a little bit of anxiety, it runs in my family, but, I'm not going to sue my dad because he has anxiety and he passed it on to me. And then, the other statement where, the accident was admitted, I wouldn't be the one to sue somebody for an accident that he already admitted.
Yeah, he's saying personally what he thinks he would do, but then when asked, does he have a problem with somebody else doing it, and he says, I need to know more facts. I need to know more facts. And to put this into context, I think another juror had expressed.
Yeah, but that juror is questioning the right of a plaintiff to sue in the first place. I mean, the question for that juror at a trial would be whether the plaintiff submitted enough evidence to prove the case. But I need more facts before I know whether someone else could sue or they should sue. That sounds to be different than,
I think when, remembering that the standard review here is abuse of discretion, and that to give the trial judge a great deal of deference with her superior vantage point in this case. And when you read through the voir dire, you can tell this judge was paying attention. She took notes. She talked about her notes. When she referred to her notes, if you go back in the transcript, she is getting it right every single time. She had granted the plaintiff several cause challenges, granted the defendant several cause challenge, denied each of them several cause challenges. She was very much paying attention and has a superior vantage point to assess whether she thought that juror had a bias that could not be set aside. And again, the Florida Supreme Court in the Morant case says jurors like Juror Beeler in this case, can set aside their biases when they're not based on personal life experiences. And so in this case, I think the judge's decision should be affirmed, based on her superior vantage point. And when you read that exchange, not from the eyes of a lawyer or a judge, but you read that exchange from the position of a lay person, I think you get an understanding that he's just maybe not quite familiar with the law. And so,
do you think the appellant should, or the plaintiff should have had to explain or provide some information as to why they wanted an extra peremptory, or why she wanted an extra peremptory to strike 113? Do you think they should have to say, look, I'm not going to go into a lot of detail, but I have some concern about 113, so that you can then meet your burden in response that why it's harmless?
Yes, Your Honor. Just, something along the lines, and I'm going to sort of date myself here. I call them Batson challenges. But where, when the concern is raised that a party has
it's like a Neal challenge, right?
Yes, has challenged somebody because of race, or sex, or some other protected class status, then the party that wants to exercise that peremptory has to give a brief explanation of the reason why. And so similarly, I think in this case, saying, hey, I want to strike this juror because I guess, as the other side said, he races trucks or whatever. There was nothing, in the transcript that suggested that this was a juror who had a bias. The plaintiff had not moved for cause to strike this particular juror, and there was a lot biographically that matched up between the plaintiff and that juror. They both were self-employed. They both had been in car accidents. And so there was nothing that looked like, well, that's why they want a peremptory. They want to get rid of this juror. This juror could be a real problem for them. And then judges, just briefly on the MDNA issue, it wasn't properly preserved. The judge did not make an error. During that pretrial ruling, the judge said, based on the representation that there's going to be an expert who connects the MDMA to the claimed brain injury, I'm going to allow this testimony in. And during that exchange, the plaintiff never provided any reason why, at that point, the offered evidence wasn't probative. So the judge's decision was correct. And then during trial, if the plaintiff believed that the evidence did not come in as it had been represented, then under the Powell decision and under the Manhard decision, the plaintiff at that point had to object, move to strike the testimony, and make whatever other motions the plaintiff wanted to make. They didn't, and so they did not preserve that issue for appeal. Because this verdict was based on sound, objective evidence, we ask that it be affirmed. Thank you.
Thank you, Counsel. Mr. Greenlee?
Thank you, Your Honors. I have a lot to get to here. With all due respect to my friend on the other side, the initial Glasgow Coma Scale was 14 out of 15. It wasn't a perfect score. Second, Dr. Oceanic, there was a CT scan dated May 4th, the same day of the accident, that showed, quote, area of soft tissue edema, which indicated that there was, quote, some sort of blunt force trauma at the head at that point. A subsequent MRI showed, quote, post-traumatic scarring in the frontal and posterior frontal area of her brain. There was objective evidence. Dr. Oceanic was the preeminent expert that testified at trial. Don't forget the defense called them the dream team. He's one of the preeminent physicians on brain trauma medicine in the whole entire United States. So the suggestion that there was all the objective evidence was in their favor is just false. The jury is not free to ignore hospitalization or subsequent medical treatment. That's the Diaz versus Spick case. Ultimately, Your Honors, choices have consequences.
Yes, wait, you run,
Yes.
once again, running away from issue 3, and it
Yeah.
seems like after Seidler, the Supreme Court has made it super easy
Right.
for a party to succeed on a for-cause challenge. And so with the respect to harmless error, it sounds like if you can make the case
Right.
that that person, the juror, should have been stricken for cause, there's not much more that you need to do. But in this instance, the appellee has actually given an explanation. They've looked at
Yeah.
the record and said there's no indication that this person was biased. Does the burden then shift to you, or is that just not enough?
No, Your Honor, and if I might, I'm completely out of time. If I might respond?
You may answer.
Yeah, 3 things on issue number 3. First of all, we're not running away from the issue. We're just here with limited time. Second of all, with respect to your question, under Seidler, there is a distinction between civil and criminal, but the only distinction is that in criminal, it's per se harmless error versus civil. Now, the burden is on them. Once we've shown that there was a denial of a cause challenge that was improper, the burden shifts to them to show that we got a fair trial, and I don't
And they
think...
did that, didn't they? I mean, why did they not do that in their answer brief?
Well, if you think about it, why did they not do that in their answer brief?
Yeah, they addressed it.
Yeah. Well, they certainly didn't carry the burden of showing harmless error. I mean, again, we have a grossly...
Is there preponderance of the evidence? I mean,
No, they have to prove beyond a reasonable doubt that the error was harmless. There's no way they proved that. We haven't... The damages award didn't even cover her cost of going to the hospital. Look at her car. It flipped multiple times. It was a wreck. And then you have MDMA use. You have all these issues and a grossly inadequate jury award. There's no way in the world that they met their burden of harmless error. And so, again, choices have consequences. It was Mr. Siebert who chose to make MDMA a feature of the trial. It was Mr. Siebert who chose to agree that the damages, conservative estimate of the damages, were $130,000. And it was Mr. Siebert who misled the trial court regarding the admissibility of the evidence. The consequences of those risky choices should be that Ms. Melgarejo gets a new trial. Thank you, Your Honors.
Thank you.